You've spent years building your business, but you haven't put a plan for what happens if you're no longer around to run this business. Most owners avoid this part until it's too late. And suddenly your family is left scrambling to protect what you have built. And in California, that can trigger probate, place you don't want your kids to be, a costly public process that puts your company's future in the court's hands. I'm Talai, a trust and asset protection attorney in California who helps business owners protect their assets before a crisis. This video walks you through a simple, effective succession plan that keeps your company in the right hands without court intervention, family disputes, or surprise tax bills. Listen, if you are running a business here in California, I get it. I run a business. I truly get it. You're busy. You're wearing way too many hats, dealing with everything from staff to sales to never-ending stack of paperwork. Planning for what happens after you're done, whether you retire, get sick, or unfortunately pass away, is probably not at the top of your to-do list. But here's the hard truth. Leaving succession planning for later is one of the most expensive mistakes a business owner can make. Let me tell you about a client of mine. We'll call him Steve for now. Steve ran a family-owned manufacturing company in Los Angeles. Everything was going great until he had a serious health scare. Suddenly, his wife and his adult kids were left scrambling to figure out how are they going to get payroll done, how our taxes are going to be paid, who's going to be trusted to run and take care of the day operation of the business. The result, the business almost collapsed, employees started quitting, and the family spent thousands of dollars on legal fees just to try to keep the lights on. Unfortunately, this is not a rare event in California with its unique laws on community property, probate, and business regulations. The stakes are even higher than most folks really realize. You might assume that if something happens to you, your spouse or your kids will just automatically step in and take care of what needs to be done. Unfortunately, it almost never works that way. Here's why. In California, if you're the sole owner and you don't have a clear succession plan in place, a few things can happen and none of them are simple. Your business could end up in probate court. That means a judge who doesn't really know your business will decide who gets to run things. This process takes months, if not years. And while this whole thing is happening, your employees and customers are left in the limbo, which can destroy your company's reputation and value, the business value of it. Or maybe you have business partners. If you don't have an agreement about what is to happen if one of you leaves or passes away, you could end up in a nasty legal battle. I have seen business partners turn into bitter enemies overnight because there is no written plan in place. California probate process is notorious for being slow and expensive. Probate fees alone can wipe out a big chunk of your business value. And if you own real estate in your business, like a warehouse or an office building, it can get stuck in a legal limbo. A lot of limboing here. So you got to make sure you put in a succession plan in place. A good succession plan answers three big questions. Who takes over when you step down, you get sick, or unfortunately you pass away? How do they get control legally so your business can keep going without missing a beat? How do you minimize taxes, court costs, and family drama? In California, you want to address these questions head on using the right legal tools. Let's break down what they really look like. Number one, choosing the right person or team to step in. This is the heart of succession planning. Who do you actually want running your business if you can't run it? Maybe it's your child, maybe it's a trusted employee or your business partner, but don't just assume they want the job because you think they want the job. You want to check with them. I once worked with a restaurant owner in San Diego who assumed her son would take over the business if, she wasn't around. Turns out he wanted nothing to do with the business. If my client hadn't had the hard conversation, her restaurant would have been dumped on someone who didn't want to deal with it at all and likely would have gone under. Here's what you should do. I suggest you talk to potential successors now before anything has happened. Get clear on their willingness and ability to take over. Sometimes your best manager is the best choice, and it may not be your oldest child. Write it down. In California, an informal promise won't hold up. You need something in writing, whether that is your operating agreement, shareholder agreement, or sometimes we refer to shareholder agreement as buy-sell agreement. You need it to be in writing. A handshake, unfortunately, won't protect your business. Here are the most common tools I recommend to clients. Buy-sell agreements. If you have business partners, this is a must. You have to have this sort of agreement. This kind of agreement spells out exactly what is to happen to your share, to your ownership if you retire, you pass away, or you just want out. It also controls who can buy into the business and how the price is going to be set. Next estate planning tool I recommend is making sure you have a living trust and you put your business's shares into a revocable living trust. You assign your shares into the revocable trust. That lets your successor to step in immediately if something happens to you. No probate delays and no court hearings. The next tool is a power of attorney. This lets someone you trust to handle your business decisions if you're alive, but unfortunately you're mentally incapacitated. In California, a durable power of attorney is the gold standard. Succession plan statement. That can really help as well. Even a simple signed statement explaining your wishes attached to your core business documents or your estate planning documents can make a world of difference. It puts everyone on the same page and heads off confusion. In California, we don't have a separate state estate tax, but the federal estate tax can still bite you, and this is not the type of bite you would like or want, especially if your business is worth more than the state tax exemption. A good succession plan can help you transfer ownership in stages while you're still alive using annual gift tax exclusions, which can help chip away at the business value that eventually would be taxable. Using trust to keep control and privacy. A living trust can transfer your business smoothly, and an irrevocable trust can reduce your taxable estate if you're looking ahead, let's say 10 years or more. A good succession plan can also preserve your asset by freezing your business value. With certain irrevocable trusts, or your heirs aren't hit with massive estate taxes if your company grows quickly after you're gone. Unfortunately, I have seen too many California businesses torn apart by family drama after the founder is gone. Maybe one child works in the business and the other doesn't, or maybe your spouse doesn't exactly get along with your business partner. Without clear instructions, arguments can turn into lawsuits, and in California, these battles can drag out for years. Your employees and customer will notice, and often your competitor will take advantage of the situation. Here is what I think you can do to avoid this disaster. Spell out roles and shares in writing. Make it clear who gets what and why. Why are you going to give your son or your daughter a particular percentage or particular ownership? It's much better when there are explanations within these documents. Consider buyouts for family members who don't want to be involved. This keeps the business in capable hands and avoids resentment. Hold a family meeting to talk through your plan. It can feel awkward. I understand. Sometimes clients tell me, I don't want to do that now. If you don't want to do it, if you think it's going to be difficult, imagine when you're not here, how your kids will have to have this particular conversation. And I guarantee you it will be much more difficult. So yes, I want you to have a family meeting. A client of mine who owned a chain of auto repair shops, she was afraid her kids would fight over the business. We talked, we set up a family meeting, and we set up a plan where her daughter, who worked in the business, got control of the business when mom wasn't going to be around, and her son, who wanted out, he didn't want to do anything with this business, got a cash buyout funded by a life insurance. No fighting, no lawsuit, just a smooth transition. Most people think succession planning is just about what happens when they die or retire. But in California, the law also considers mental incapacity. If you get sick, injured, and can't make decisions, we need to make sure we have a plan for the business in place. And if you don't have a plan in place, someone will have to go to court to get a conservatorship for you just to keep the business running. And that process is expensive and slow. That process is slow and public. Your business finances can become part of the court records. So please protect yourself by naming a backup decision maker. Use a power of attorney so that your agent could make business and financial decisions when it's needed. Keep your business documents current. Laws change, and so does your life. Review your estate plan every 3 years, especially after a big life event. If you do nothing, you leave your business and your family fully exposed. In California, a business without a clear succession plan is at the mercy of the state laws and courts. That means months or years of probate, mounting legal fees, and also possible forced sales for your business. Even if you're healthy and running strong, life changes fast. Many of my clients come to me after a crisis. By then, options are limited and the stress is high. Planning ahead is really a gift to your family, to your employees, to your business that you've worked so hard to build. So take actions now, protect your company, protect your family. Here's what we covered. The biggest risk facing your business if you don't plan for succession. How the right documents can keep your company running no matter what. Why taxes and family fights can destroy your legacy if you leave things to chance. And the simple step you can take right now to put a safety net in place. If you want to go even deeper protecting your business and your personal assets, you're going to want to watch the next video. Bankruptcy versus Asset Protection Trust, Last Resort Options in California. In it, I will break down exactly what happens if creditors come knocking and how you can safeguard your hard-earned wealth and your asset even in the toughest situations. I look forward to seeing you over there.